So let us understand the essential elements of contract. The first being the offer and acceptance uh, of an agreement. Students, please understand that in order to enter into a valid contract, there has to be at least two parties. So one making the offer and the other person accepting it. So and the offer and acceptance must be a valid one. Matlab in the eyes of law, it has to be valid. It has to be legal. So there must be at least two parties, one making the offer and other accepting it. And suppose in case if the offer or acceptance is not valid, then it will be considered as void and it cannot be constituted as contract. So in the case of Gujarat versus Ramanlal and Company, there is a decision as to that where the partnership firm is dissolved and the assets of the firm were divided among the partners. So the tax officer wanted to tax this transaction, but however, it was held that it is not a sale because the partners and the partnership firm are one and the same, by saying that partners are the joint owners of the assets or estate of the firm. So it is a conclusion that one cannot sell goods to himself, isn't it? So there has to be a two parties. From that perspective, an agreement or a contract, not an agreement, agreement which is enforceable by law is a contract, has to be there. Two parties, one offerer and another is offeree, meaning the essential element is that offer and acceptance has to be there and it has to be valid. And the next point is the parties must intend to create legal obligation. So what does it mean, sir? Intention to create legal obligation. Generally what happens in the social agreements or domestic agreements, there is a no intention to create legal obligation. So what does this social agreement is all about? Where the parties do not intend to create legal obligation. For example, if your friend or if your relative invites you for the dinner or lunch, so they are calling it on the for the from the sake of social aspect and not from the contractual obligation. So from that point of view, if the agreement is not creating the legal obligation, then such agreements cannot be considered as contract and they are only the social agreements. They are not enforceable under the law. So, in a landmark case, Balfour versus Balfour, wherein the husband agreed to pay his wife a certain amount every month, and later on, when he fails to pay the promised amount, wife sued him for the recovery of the amount. But however, the wife could not recover as it was a social agreement and the parties did not intend to create any legal relationship. So this will become a very a landmark judgment from the perspective of if the parties do not intend to create the legal obligation, then it will not be considered as contract. Then moving on to the next essential, the capacity of the parties to the contract. Students, the parties to an agreement must be competent to contract. So, in other words, they must be capable enough to enter into a contract. I just want to point out here is there is a reference to the section 11 of the Indian Contract Act, which states that every person who is of the age of majority, section 11 of the Contract Act covers the age of majority and who should be a sound mind person and should not have otherwise disqualified from contracting by any law to which he is subject. So it means it is disqualifying the minors, it is disqualifying the unsound mind persons, unsound mind person, and it is also disqualifying the certain specified persons such as, for example, convicts, insolvents, or corporations. They are specific parties with whom you cannot enter into contract. So capacity has to be there, matlab competency has to be there, as well as the legal ability uh, in order to enforce the contract contractual obligations. And next important element is that lawful consideration and lawful object. An agreement has to be supported with a lawful consideration and lawful object. Section 23 defines this particular aspect, that consideration is considered lawful unless it is forbidden by law or prohibited by law, or if it is such that if it defeats the provisions of law, it will not be considered as unlawful, or if it is fraudulent, or if it is involving any injury to the person or the property of another, or courts regard it as immoral or opposed to public policy, then we cannot call it as lawful consideration. In such case, the agreement is not valid. So it becomes illegal and unlawful, and agreement renders to be void. So the example here in this case is when A promises to drop a prosecution instituted against B for robbery, and B promises to restore the value of things taken. The agreement becomes void because it is unlawful, that restraining or stopping the legal proceedings is against the law. So this the in nutshell, it means the essential element has to be there from the lawful consideration point of view in order to consider it as a valid contract. The next part is the free consent. See, consent here means agreeing upon the same thing in the same sense, in the same manner. So, whenever a party is enter into a contract, there has to be a consent, meaning the both the parties should be having agreed upon the same thing in the same sense, in the same manner. But if there is no consent, it will not be a contract. And here we are discussing about the free consent. The consent of the contracting parties are not only necessary, but the free consent is also necessary. So it means along with consent, there has to be a free consent, meaning if it is not caused by coercion, undue influence, fraud, or misrepresentation or mistake, if it is caused by these reasons, it is not a free consent. And what we are referring is, it should not have caused, the contract should not have entered by causing these elements. If these elements exist while entering into a contract, then it is void. Later on, we will understand, rather than it is void, it becomes voidable. When the free consent is not there, the voidable is more specifically covering in the case of free consent case. It is a voidable contracts and not void contracts. We will be able to explain in upcoming sessions about what is void and voidable contract. As of now, you please understand the free consent point of view, because voidable is a technical term which we need to explain in detail. Moving on to the next essential element, not expressly declared to be void. The agreement must not have been expressly or impliedly prohibited by law under the provisions of section 24 to 30 of the Act. See, law has provided certain activities as void. So those activities should not be covered. Otherwise, it will be treated as void agreements or void contracts. So, for example, if Mr. A offers Mr. B that he will pay 1 crore rupees for not getting married in his lifetime. So this is basically a restraint of marriage. So all agreements in restraint of marriage is void. And also there are a couple of examples like restraint in legal proceedings, restraint of trade. So all these comes under void agreements. So it should not be a void transaction in order to consider it as a valid contract. Moving on to the next essential element, that is certainty of meaning. So the meaning has to be certain enough that it should not be have ambiguity or vagueness at the time of entering into an agreement. So in this case, when Abhinandan is agreeing to sell Bhuvanandan 1 liter oil, so here it does not specifies what type of oil he is intend to sell. So it is not certain, hence it is a void agreement. So it will not be carrying certainty to its meaning. The subject matter is confusing, vague, and ambiguous. So hence it is not we considered as valid contract. Another important essential element is that possibility of performance. So whenever the party is entering into a contract, the terms of an agreement should be capable enough to perform. If it is we are unable to perform, then it is a void. We consider it as void. An agreement to do an act which is impossible in itself cannot be enforced. Even the court of law also cannot enforce such transactions. So when A agrees with B to discover the treasure by magic, it is not possible. Hence, it is a void transaction. So even when a person is entering into an agreement to make the dead person alive, that is also an impossible act. So hence, such agreements are void. And the last essential element is that other formalities to be completed. The agreements, whenever the parties are entering into, they have to comply with necessary formalities, such as it has to certain law says it has to be in writing, or it may have to be registered with the respective authorities, or it has to be properly stamped. So such formalities have to be fulfilled in order to make it enforceable. For example, in the case of purchase and sale of real estate properties, the seller and buyer has to ensure that the transfer of the property must be done properly through a written and it has to be properly stamped and it has to be registered with the sub-registrar authorities. So other if these formalities are not fulfilled, so the court of law also cannot enforce it from the parties to perform it. So whenever there is a formalities enumerated or specified in any of the law to that matter which is applicable in India, so that formality has to be fulfilled in order to remain that agreement as contract, or in order to call a valid contract, the formalities have to be fulfilled. So I hope you all have understood these essential elements of contract. In our upcoming sessions, we will be discussing on the different types of contract and the various case scenarios, which is helpful to understand these concepts. Thank you.